Perfect.
Okay, hello everyone. Welcome to the Hodlcast. Today is January 20th, and we have special guest Aaron Krowne. Aaron, we had you on the show last year after the SEC put out its framework, I think around last April. But if you don't mind, can you give kind of a little introduction to yourself and how you got involved in this Bitcoin space?
Yeah, sure, Sasha, and thanks for having me. I am originally like a CS guy, CSIT, so I worked in that field starting from the early 90s. I was into privacy and data security for a long time before it was cool. So that's been my thing for a while. And I was also into economics and finance. So in the 07, 08 financial crisis, I did blogging and publishing about that. That got some notoriety. And then after a few years of that, I switched tracks and decided to go into law. And that was after getting more acquainted with legal issues in running a business. So I did that, and I thought I would go back sort of and circle back and combine that with tech and business. And so combine those elements and be able to advise people who are in business and technology areas, sort of like the former clueless me that was in those areas, and make that what I do. So that's what I'm doing now. And I had sort of I had been following Bitcoin from when it came out, and blockchain, as an outgrowth of that, and pretty much from 2008 or 2009, starting with the Bitcoin paper, and was really excited about that. And I didn't do anything really professionally with it, but played around with it as a hobbyist for a while, and was evangelizing it to people I knew and things like that. But when I got out of law school, I was in practice for a few years, and then in 2017, the whole area of the blockchain area blew up with ICOs. So suddenly there was this tremendous business interest in it. So at that point, I started to have clients and potential clients approach me about doing something in blockchain, and coincidentally, I already knew it. So I was able to switch in with feet, and that's what I do now. So blockchain law is the main thing that I do now, and that's sort of combines everything I was into before. So it's a nice fit.
Oh, that's great. And yeah, it's a powerful combination having that background you have and then mixed with the law and the curiosity on Bitcoin, and it all works very well for you, I believe. And you
Yeah,
recently
definitely.
wrote, it's hard, but just to back up on that, it's hard to find, like, a lot of attorneys don't have the legal, economics background or banking background. So it's hard to find someone with that mix that you have. So it is very, very helpful.
Yeah. It's like sort of a jack of all trades, but in just the right area. So it's actually really useful
Yeah.
into blockchain law.
hmm Your recent article, so you published an article about the New York, the proposed listing policy framework that they published on December 11th, 2019. So can you maybe give us a little bit of background, what is the BIT license for anyone that doesn't know? Just probably most people have heard of it, but maybe a little background on the BIT license and what companies
Sure.
have the BIT license for now, and then we'll get into the new, stuff that New York's coming out with.
Yeah, absolutely. So the BIT license was put out by the New York Department of Financial Services, and they did that actually very early on, 2015. I believe it was one of the first global laws or regulations tailored towards crypto. So in that sense, it was very progressive, but people didn't like it in the crypto community to a large extent because it's actually pretty heavy-handed regulation. I mean, it's a $5,000 application fee just to even get started. So I mean, that's not done lightly, and it essentially prohibits almost any crypto-based business in New York as a customer business if you're not licensed. And that's even if you have a single New York client or a headquarters in New York, even with no New York customers. So it's not lightweight. It's nice, that they were thinking about crypto and wanted to kind of make it a respectable area. So, great props to the New York DFS for that. I think in terms of fostering business activity, it was fairly heavy-handed and remains so today. So, and that's part of what I discuss in my article, not only about this new proposal, but generally. So, but you can actually think of it as like a money transmitter license, but geared specifically to crypto. And it sort of is an outgrowth of money transmitter licenses. And probably New York created it after being approached about, whether people need a money transmitter license in New York, which is a process that I go through with clients, as you know as well. Anytime anybody's looking to do any sort of official business with crypto in the US, they have to go through this process of figuring out whether they need state money transmitter licenses, and if so, in which states, or how do they structure their activities to not need that. So this is kind of an outgrowth of that, except one thing, I can certainly credit New York for is they made it very, very certain that you do need this in most areas of business. No real question about it. So they cleared that up, which is great. But it's not a walk in the park. So it's something that's done seriously, and only a relative small number of companies have acquired the license. So it's actually, I just checked, it's 24 now.
Okay.
Or actually 22 full licenses, and I think it's 2 charters, trust charters. So that would be, I believe that they use that language for a regulated trust that got a kind of waiver or permission under the BIT license rather than the full license. So it's really just a couple dozen as compared to the crypto space, which is huge. So it's quite a funnel that narrows things down. In the names on there are names like Coinbase, Gemini, Bitflyer, Bitstamp, Zappo, Square, BitPay, CoinSource. SoFi was the most recent one. There's Tagomi, a couple of Bitcoin ATM companies like Cottonwood Vending is another recent one. So it's a lot of the big names doing business in the U.S. So that's in a way a benefit, because if you do pass the hurdle to get this thing, it's a huge show of credibility. So that part of it is really good. But it does sort of favor the larger. We have another participant in this interview here.
Yeah.
That's awesome. Yes. What is a crypto interview without a cat involved at some point? Perfect. But yeah, so it's a fairly high hurdle to jump over. So only a few of the biggest companies have. So it's not very friendly to the smaller upstarts or people that have only a tangential connection to New York. So I think it does is a side effect of being such a high bar, kind of firewall companies out of New York, unless they make basically a huge commitment to go into the state. So that's basically the big picture of it.
Mm-hmm. And we saw it come into the litigation around, I think it was Tether earlier in the year, where they were saying they were purposely staying out of New York, and then they were using a bank account. Like they didn't even, supposedly didn't even have any clients in New York, but because their bank was in New York, that, I think it's still ongoing in the litigation phase, but it was
for sure. Yeah. In the jurisdictional boundaries are one of the fuzzy areas of this whole thing. And, as a typical process, the state starts out asserting something which is as broad as they possibly could, because, to credit them with the nicest motivation possible, they want to protect the public, right? But it might even overstep the boundaries under interstate commerce law. So, that's one of the things that needs to be hashed out still. And actually, I wish there had been more litigation over the BIT license, because there are some really practical issues in exactly how far the coverage goes. And it's just a situation where people have either not gone for it after seeing, how substantial it is, or they have gone for it and they're wealthy enough that they just, go along with it and pay for whatever they need to go through to qualify. So yeah, I wish there had been more litigation. I'm sure there eventually will be, but there are a few issues like that.
Mm-hmm. And so what are the two main prongs that are proposed in their December framework?
So the new proposal, which came out in December 11th, in really a very rough sketch form, I would say. So I think they're actually really seeking comments, I hope. But what they wanted to do is apparently give people a way to be able to deal in coins, again, as an official customer business, and not have to ask the DFS every single time for permission to deal in those coins. And they call it coin listing in most places, except one place in the proposal. So it's a little confusing as to how broad the coverage is on that. So that's something I hope they clarify. But they do call it the coin listing proposal or process. So that sounds great, right? You can go through some process, and one part of it is sort of a self-certification process. So you won't have to interact with DFS as much. Again, good intent, but I think there are practical complexities of it, which we'll talk more about. But it breaks down into two prongs. So the first prong is if DFS decides to allow everyone to use a coin. So it's sort of like a general or global list. So we can imagine them putting, Bitcoin and Ethereum on there, and probably a few of the other top coins, and just saying, yeah, those are all good. Probably all or maybe most of the ones that Coinbase allows on the main exchange is probably a good bet. And then the second prong is if there isn't something that's not on that list, but you want to deal in it as a Bitcoin licensee, but DFS hasn't considered it, or maybe they did and they didn't think it's good enough to be on the general list. I don't know, but they said essentially, if you have a policy for screening and approving coins, and you make a good faith effort to apply that policy, then you may self-certify additional coins to use in business. So it sounds really good, right? Like you can wait for them to approve something or do it yourself. But there are definitely some challenges in that.
Like what will it require? Pre-approval, or if a coin is not listed on that safe list that they give us,
right?
Will companies need to request pre-approval and wait for that, or are you able to just list it based on your own assessment of their criteria that would probably get approved?
Right. So we don't know anything about how something will get on the main list. Mm-hmm. So I have essentially nothing to say to that. And that's one of the things I put in my feedback is tell us what would prompt DFS to look at a coin for the general public listing. Can you advocate for one? How does that work? So we don't know anything about that yet. As far as then the self-certification under prong 2, my read of this is that it's not a pre-application, but it is a self-executing process where, as long as you come up with a compliant policy, you can apply it to a coin and just decide on your own to list that coin or not list the coin, or even potentially broader than listing, use it at all in business as a customer business in New York. So that again seems great. If you can just move forward on your own, it's more overhead, probably more paperwork. I would sure as heck save all the records of doing that sort of evaluation in case the DFS, asks you about it. And that's a key point, is actually they do say this in the proposal way down at the bottom, this is not a guarantee of anything. If you do this, we can still come back and disapprove a coin that you've allowed yourself, basically self-certified, to use. So it is post hoc for sure, and they can overrule you essentially. But that raises additional questions. So it's not quite as great and happy-go-lucky as it seems at first, because imagine they don't agree with you. They come as they interact with licensees at least annually because they're licensed, and it's a continuous interaction. Maybe they see that you're trading in another coin and they say, well, wait a minute, we think that one has these big problems, and we don't think you should be able to list that coin by your own policy, or maybe even your policy isn't adequate for screening these coins. So there's a couple levels that could happen on. But then the question is, what happens? Do you get penalized for the entire time you were dealing with that coin? Is there some sort of damages?
Mm-hmm.
Do you just have to stop from that point? And as long as you did so in good faith, that you won't have any fine or penalty imposed on you. So those are important details in terms of analyzing the cost benefit of doing this, and for us advising clients, right? So these are really considered sort of details, but they're actually in a way the most important thing, right?
Yeah.
If the worst that can happen is, I don't know, it's like $1,000 fine or something, one time, then no big deal. You can sort of run forward and make a good faith effort to screen coins you want to list and list them. And then if the DFS says no, okay, it's not going to like render your company bankrupt, to get fined or something like that. But if it's, every day you were dealing in this coin, $1,000 fine, it might be a dramatically different calculation.
Yeah.
So they haven't supplied any details on that, and I don't know if they were planning to, but I hope that with prompting from me and others, they will think about these things and try to lay it all out so people can make an informed judgment.
And it would be really nice to know the criteria that they're looking at for, what coins would go on their list and what don't. Is it from a securities law perspective, a money service perspective, like a volume of trades on the coin, the reputation of the coin, how big its community is. Like, we just, from my read of it anyway, there's no interpretation of what's going to be an approved coin or not, and what they're basing it on.
Right.
Mm-hmm.
Yeah, I mean, one of the things I suggested is allow people to advocate or submit for a coin. Maybe you can make the DFS evaluate one if you pay like a bit license fee and you apply generally. But if you can self-certify, I don't know why you do that. So it's a little bit of a conflict.
Yeah. It's a bit of, and why, to go through all that for New York when the rest of the, not the rest of the country, but a lot of other states don't require anything like this. So it's, but.
Right. And that's something a lot of people have gone through strategically, when thinking about how to build out their crypto business globally, is, do we even go into New York? Because we have to deal with this thing and the bit license that is. And this makes it more formidable. So I want to be completely clear about that. Above everything else, what this does is, as far as I can tell on how they wrote this, it prohibits you from using a coin unless it's cleared under one of these two mechanisms. So actually, you need to be bit licensed if you fall under that category of activity, and then in addition to that, you need to have a coin-specific certification. So it actually is negative regulation fundamentally, even though it has sort of this progressive idea of making it easier to certify coins. Well, you didn't have to certify them before, at all. So it was all just sort of under the informal screening of the bit license in terms of what your business model was and, are your practices sound? So it is a categorical change, and that's the thing I want to highlight above all. So this is the calculation that people are going to have to think about when considering going into New York, and also in terms of getting their coin to have broader uptake if they're issuing a coin.
Mm-hmm. Yeah, like the question before of what exchanges you could get listed on, now they have to, meet this extra hurdle of and then probably a lot of people will follow this list as their, safe list or whatnot. So it'll make it, I think, more difficult for even companies that aren't registered with the bit license will probably only list the coins that are allowed through the bit license if they're kind of illegally operating in New York. I
Yeah, I mean,
many
there's
exchanges, but we know there's a few out there that are doing it. But
right.
what is
Yeah,
so
all
what
kinds
does
of
this all
unintended consequences.
yeah, yeah. What does this all mean for like a startup company? How does this impact them if they're launching a coin?
Yeah, that's in a sense who I'm most worried about. I do a lot of representing startups. I don't feel too bad about the Coinbases of the world about having to go through the bit license. They can afford it. It's fine. I mean, the process is pretty slow, so they should probably try to figure out how to speed it up. But if you're well funded, it's not a big deal. Yeah, the concern is really the startups, I'd say. So if you're issuing a coin for your project, and I know there's much of that going on, sort of freewheeling like there was a couple of years ago, but it is still a core process of engaging in some sort of venture in blockchain is coming out with a coin. When you do that now, you have to look at whether you want to try to get into New York for business purposes. So like people were doing before when they had a startup and considering where to actually be based or where to have an office, at some point they would look at New York because the US is a huge market and New York is one of the biggest, most influential markets in the US. So that was a frequent thing where people were looking at New York for basing their project or just having some sort of office or some sort of official activity, and then they had to consider whether to go for the bit license. And probably most startups, and I'm including in this well-meaning ones that are doing all the right things, but it didn't originate in New York, or maybe they did, and they're reconsidering that choice. But they actually are turned away because of the high barrier, sort of hard stop to activity that it presented. Well, now, if you're just issuing the coin on top of that decision, or even rule that out. So say you're based in Estonia, which is the example I use in the post, and that's a jurisdiction. It's not sketchy. It's a European Union country. It has its own legal regime that applies to crypto informally, and you may comply with everything locally and in the EU, and you want to allow your coin to distribute around the world so people can participate in your project. For the sake of this example, let's say it's commercial, but you look for every regulation that you fall under in your country and in the EU, and then maybe in a third country where you're on some sort of crypto exchange. You comply with all that. Doesn't matter. On top of all that, now, if you want people in New York to access your coin, they can't. If they're a bit licensee, they still can't, right? So unless your coin is now explicitly on the public list, or it goes through this self-certification process of each and every bit licensee, they can't access it. So New York customers can't access it. So again, you may think that's fine, an extra layer of protection, but the calculation from the startup's point of view now is, oh God, do we go through every bit licensee on the list and try to get them to list our coin? And then what do we have to do that? And does that turn into a process like what the process for crypto exchanges has turned into, where it's this huge deal of paying them and going through another evaluation process and trying to sort of it's like Oscar season, trying to promote your movie to get Oscar consideration like every single time. So how far is it going to go to get your coin to be able to be traded in or listed in by New York companies now? That's sort of the setup. I don't know how bad it's going to be or how things are going to shake out. But if this is what it comes down to. I mean, if there is a hard stop on bit license holders dealing in coins in New York, that's the sort of dynamic you're facing. So that's the setup. And I think a lot of startups coming from outside of New York will see that and think, well, now we really are not going to bother with New York, right? Maybe we'll just wait a few more years, and if we get big enough, we'll hope the DFS, publicly allows our coin, or that bit license holders will just on their own evaluate our coin for listing, without us having to basically promote ourselves to them and pursue them for that. So that changes the economics of it, I think.
Lofty goal, though, because it's like without having the coin listed on the exchanges, it's hard to, which comes first, the listing or the demand.
Right.
But
yeah, so that problem gets worse for sure.
Mm-hmm.
So that is the situation. And one of the things I suggested in my post to make it, to ameliorate it a little bit, is rather than making it a hard stop on using a coin, to make it a safe harbor. Mm-hmm. So, for the viewers, what that means is that you put some conditions on using something that you would normally need to get explicit regulatory permission for, but you say, okay, you can do it if you follow A, B, and C. And A, B, and C could be that you can only do a certain amount of business in it, or only have a certain amount of customers, or that you have greater liability if your own determination is wrong, something like that. So the idea being to just allow people to deal in coins, but don't bring the hammer down completely if they follow certain conditions. Mm-hmm. And the self-certification could be that, but I think that more explicit language would be needed to say that, if you've done a good faith determination, then here's what your protections are.
Mm-hmm. And how does this layer of regulation compare with other regulations that crypto companies face or interact with? Like, does it add more protection, or are these things already protected for the other states that don't have a bit license through certain federal laws?
Yeah, that's a good point. So it appears to be completely redundant with everything else that's out there. So one prominent example is securities. So if your coin or token is a security, you're regulated under securities laws. Either you're exempt, like under Regulation D, or you're registered or quasi-registered, like under Regulation A. So in any case, you are doing certain disclosures, you're following certain rules, you have certain there's certain conditions you have to meet about the company and the founders, and there's reporting in some cases. So all those things are regulation, right? And it's quite significant. Actually, I should mention that you're subject to anti-fraud provisions under the Securities Act. That's a big one. So committing to all that and going through that process is major. It's a sliding scale depending on how much you do, but it is not nothing. So if your token is a security and you have gone through that process, doesn't help you in terms of this coin listing proposal, at least. So I think that's a major point, and I think that the state should really, or the DFS should really consider doing something to make that level of regulation less redundant. So that's a big one that a lot of people in the crypto world are using. They're doing security token offerings, or they're issuing their coins as a security, even though they hope for it to be a utility token eventually. That should be acknowledged, and it's just just as a pure efficiency point, that would just save everybody a lot of hassle, and still achieve the objectives of having a certain amount of screening and regulatory scrutiny. Um,
Mm-hmm.
and, you know, basically putting it all in front, which is sort of what the anti-fraud provisions of Securities Act is, you know what you're getting on board for. So it's sort of, it sort of washes out a lot of the bad actors before they even do anything. So I think that's a major example. But more fundamentally is the bit license itself. So that's already there, doing a lot of what I just said, which is it's an evaluation of the company itself, the founders, covers financial solvency, covers cybersecurity, capitalization. It covers business continuity, all these aspects. There's regulatory application. You may not get approved. There's interaction with regulators. There's regular review. Their annual requirements. It goes on and on and on. It's a lot. So the whole point was that when companies go through this, we can be pretty assured that they're sort of on par with traditional regulated financial companies.
Mm-hmm.
So it's sort of like, what more do you need, right? So why do we also need to have some sort of approval or self-certification for every single coin, right?
Mm-hmm.
What really is the risk? I mean, if the
Yes,
instrument
on
can be bad, if
mm-hmm.
the coin could be bad, well, that's really different than the stock market or the foreign exchange market. So,
Yeah.
why do we have this?
Yeah, you brought up the foreign exchange market in your article too. How does this regulation differ from that regulation? And what do you think the difference in risk between Forex and crypto trading are?
Yeah, that's thanks for bringing that up. That's a very interesting parallel. I don't work in that area. I'm somewhat familiar with the regulations just because you sort of can't avoid coming across them working in this area. But from what I understand, the foreign exchange regulation, it focuses heavily on capitalization and then sort of the same financial soundness and governance controls and financial controls that you see throughout the financial space. And the capitalization might even actually be higher. I believe you need 20 million capitalization to be a forex dealer under the CFTC.
Okay.
So it's substantial, right? But it's focused on the entity, the business itself, not on the instruments that they're trading. So that's interesting because a currency is in a lot of cases like a crypto coin, right? I mean, Bitcoin came out to be sort of a virtual currency. In fact, that's the language the bit license uses. It's a language a lot of the regulators use. And in a lot of use cases, these coins are serving essentially as a kind of currency. So they behave in the marketplace in a lot of similar ways. And if it's a security, like your token is representing equity, fine. That's probably a different case. But in a lot of the cases, that is what the sort of purpose the coin is supposed to serve, which is to be kind of like a foreign currency. It happens to not have a country issuing it. So, it's a lot of the time the same in intent, and a lot of the time also the same in how these things are traded in the marketplace. So I think it's a very persuasive case for potentially how to regulate crypto coins is to look at the forex space and sort of go through the mental exercise of, well, if something isn't needed in forex, why do we need it in crypto financial regulation? So that's sort of my thinking behind that. And then when you look at it through that filter, well, forex dealers aren't going and getting approval or having to self-certify for every single foreign currency that they list. Instead of sort of a whitelist system, which is what that is, it's more of a blacklist system. So the presumption is you can deal in anything unless it's like a sanctioned country, North Korea or so forth. So Um, I think that is probably a more appropriate system here. And actually, one of the reasons is an implicit or explicit goal of the foreign currency space and really free markets beyond that is to allow risk to be discovered and priced in it's called the risk pricing function of the market. And if you don't have that, it actually makes the market less efficient, and you may actually cause greater harm. So I think it makes sense to look at the Forex space and some of these other financial regulatory spaces and ask ourselves if we need an extra layer of restrictive regulation for crypto, when in fact, opening up the market more may actually allow it to become more efficient and actually protect people more.
I like that argument. Yeah. And then, so what are your main recommendations here for prong 1 and 2?
Yeah, so one was one I touched on before, which is to make the whole apparatus more like a safe harbor.
Submit these to New York, these recommendations, or are you planning to?
Oh yeah, yeah, I have. Yeah, I did a version of the post for them and sent it in. So I don't know if they would pay attention to little old me, but maybe with a few more people.
The overall
sending in
community
comments.
should be thanking you, because I doubt a lot. I didn't even hear about these this thing coming out until I saw your post.
Yeah.
So,
yeah, it was. I mean, it came out. Everyone I think had checked out mentally for the holidays already. Yeah, so I was sort of trying to jumpstart things again, but I think they want feedback. So it doesn't have to be totally adversarial. So I try to really think constructively of how to make this better and not to sort of make this the bit license sucks, let's just oppose everything. No, I think it is possible to have productive regulation that actually makes the space more credible and ultimately more generates more economic activity in the long term and is good for the public. So that's my perspective, regardless of whether I would have wanted the Bitcoin in the first place, or the bit license, sorry. Mm-hmm. So, I've stuck to that tack, and I hope other people also take that tack and send in some productive comments, and hopefully we can refine this, and get something that works well and doesn't add another a big negative for people that are considering dealing with New York or coming to New York. So, on that note, one of the big ones was,
what are the main recommendations you got?
Yeah, the big one, so I would say, is sort of broadly make it more of a safe harbor. So more of a blacklist situation than a whitelist, so that if a coin isn't on the DFS list, and fine, you can self-certify, but in that case, basically what you're getting into, what the worst that can happen is, essentially. And even actually, if you don't go through the self-certification process, but if you just use the coin without any methodical process, what's the worst that can happen to you then? Maybe that case is worse. But certainly in the case of self-certifying, I would say it should be more like, there's a couple examples actually. One would be issuing private securities under Regulation D, so that the private accredited offering, it's similar in that it's sort of self-executing, except for one filing of a Form D. But there's a lot of stuff you have to follow internally. And however, if you do that, then the SEC can't come in and say you didn't do enough to prove your investors were accredited, right? So that's a big one. So that's extremely, extremely useful. I mean, it really sort of squares the circle in the securities area. And I think that we even take that for granted now, because it sort of works so well in the background that people don't think about it. But, we have a pretty good compromise in that system of the level, the extent to which you can issue securities without having to basically run your investors through a ringer, to prove that they absolutely, possibly, every microsecond have to be an accredited investor. So that's a nice safe harbor. There's a number of other ones in the securities laws, for example, around Regulation S, with the offshore offering of securities, which is another exemption. So those are good examples. Another one actually that hits close to home is New York. They have a new data breach and privacy law called the Shield Law, which goes into effect this year. I believe it is May of this year. Don't quote me on that. And in that one, it has sort of a similar structure where you can self-certify your cybersecurity program and practices if you are under a certain number of employees or a certain scope of your business, and I don't have the numbers offhand, but it's pretty reasonably tailored. But then if you go above that threshold, you have more mandated requirements. So it's that it actually illustrates 2 points that I brought up in the proposal. One of them being having a phase-in or a threshold, and then the second being a safe harbor. So you in the one case you follow your own cybersecurity protocols that just hit a few high bullet points, and then in the second case, if you pass the threshold, you actually are mandated to do a larger list of things. So I think that they should try to follow that in the context of the bit license, generally, as well as with the protocol. So those are a couple of things: the safe harbor aspect and the thresholding aspect. There's a whole laundry list of other things I have in here. For example, let's see, pull up my list. Yeah, so they actually never clarified whether listing means just like an exchange listing, like Coinbase has, or whether it's any business use of a coin. So that's something they have to clarify. My preference would be to restrict it to just like Coinbase type scenarios where you have an exchange, but I don't think that's what they mean. So it is what it is. But they should certainly tell us which it is. So that's just a clarification point. As we touched on before, clarifying which factors would trigger the DFS to consider a coin for public listing. So again, another to verify. Exempting coins which are security tokens. They could even do that in reciprocation with foreign countries that have their own securities listings and exchange listing conditions for tokens. So all of that would save us a lot of trouble if we just recognize those foreign regimes and other regulatory regimes in the U.S. and have an exemption or some sort of reciprocity. So those are almost like a no-brainer, I think. And then I suggested that people could actually pay to have the DFS review a coin, a lot like the bit license itself. So that would actually give people who have introduced a coin a way to just sort of skip over having a few dozen bit license holders have to, in every single case, look at a particular coin. And then those are the main ones. And for the second prong in specific, I suggested not only allowing an individual company to self-certify a coin, but also allow a SRO or self-regulatory organization to certify a coin. And then any member of that SRO, any member could just adopt that essentially. And there are now some SROs starting up in the crypto space. So that, I think, makes a lot more sense than having it be a company by company, coin by coin process.
Yes, absolutely. I agree with all of those recommendations completely.
Awesome.
You gave it a lot of thought before, before coming up with them, but they make a lot of sense to have, especially the safe harbor. Just give it, a little bit of time and the criteria. Those, it's pretty hard to self-certify if you don't know what criteria you're certifying it under.
Right. Yeah, that's actually another point I don't think I really touched on earlier, which is they're supposed to, the DFS is supposed to give us like a template for a coin listing self-certification policy. That's going to be great, when they do that. But then, the question is, how much can you vary from that, and how harsh is the penalty if in applying that the DFS comes to a different conclusion than you do. And on a lot of these things where you're making a risk-based determination, it's a situation where reasoned minds can differ. So they really need to say, what the penalties can be, or, okay, this is just a safe harbor. So, you really can't lose out by making a good faith application of this.
Mm-hmm. Now, is there any way to get around this if you're like, what if TD Ameritrade wanted to come and start listing security tokens on their stock market? Would they need to go through this whole bit license process, or is it only for crypto companies?
Yeah, that's an interesting point. It's a banking or a company regulated under the banking chart or the banking act in New York. So a bank or like a trust company, they actually don't need the full bit license, which is acknowledging the fact that they already have most of this regulation sort of satisfied. So all they need under the bit license is sort of like a waiver or approval. And I think that is what the DFS is referring to when they say they talk about some of the grantees who have received a trust charter, a bit license charter. So Gemini and I believe is Paxos and Gemini are the two that have received that. So they formed like a trust under the Banking Act, and then they said, okay, now we want that to deal with virtual currency. So it's not a full application. I haven't been through that, so I don't know exactly how intense it is, but I think it's probably pretty minimal because they've already been approved as a banking entity. So I would imagine that the same goes for the TDs of the world, as they also have a regulated bank. And I believe that what they have to show then is just sort of what is the marginal additional diligence that they've done to show that they can handle crypto. So it is it's significantly more lightweight, and if you're going that route, you're already it's ironic because you're already a large entity in almost every case. So it's like, well, okay, great, you've made it easier for
these little small companies.
yeah. So okay, well, nice for them.
But I guess by getting large, you've shown you have certain know-how or skills to operate a large banking company that some of these other smaller players have not yet demonstrated. So.
Right, and in that sense, it's meaningful. And I want to make clear also that the aspects of the bit license where you have to show the safety and soundness, all the different dimensions from cybersecurity to business continuity to financial soundness and all that. I mean, that's all really good material, but it forms the license overall forms such a hard stop to entities that are trying to get started up, or those that they only have a tangential connection to New York. So it may be worth not going into New York or avoiding it. So that dynamic, I think, gets worse. Mm-hmm. Yeah, that gets worse with his proposal, and sort of gains this new dimension of, oh geez, do we want to deal with this in getting our coin out there? So that's really the issue. That basically the edges around this thing could be softened and made a little bit more conducive to sort of wooing businesses into New York, and then maybe graduating the requirements so that as they grow, then the requirements become more formidable and more expensive.
Yeah. And so when is this regulation set to become effective?
Yeah, that is a very good question. Actually, we don't know. They didn't give anything in the proposal. That's part of what makes me think it's more of a consultative process. So that's good. They did say that they will circulate this proposed listing policy. They didn't say when that will be, but it's sort of another step in the process. So I imagine this would probably have at least an additional 3 months or so built in to whatever you might estimate otherwise, which who knows, 6 to 9 months, but it could be anything. And maybe they'll get feedback and do a more detailed proposal and get comments on that. I really don't know what the thinking is, but it's sort of uncharted territory. They were the first regulator to sort of do it this way, and one of the ones who has gone really the farthest in the United States. So there's not much of a map for it, and yeah, it's just sort of a wait-and-see process, and of course, try to get your comments in. Again, we have a week now.
So January 27th.
January 27th. Yeah.
How do you get comments? Like, if anyone listening to this decides they want to submit some, what's that process like?
Yeah. So it is on the proposal itself, but I'll just relay it here as well. So it's innovation@dfs.ny.gov. Just send them an email with the title "Proposed Coin Listing Policy Framework," and then put your comments there. I mean, I sent like a Word file as an attachment and said, see here, there's comments.
Mm-hmm.
Yeah, so I'm sure that anything reasonable that you send to that email, they will be able to read and digest. That interestingly goes to a what's called the Research and Innovation Division of the DFS, which was actually created last year. So I don't know really what that entails. I guess the hope being that it's more focused on financial innovation, so maybe they'll pay more attention to this and really consider the sort of productive suggestions for how to make this work better and achieve the public protection purposes, as well as actually fostering the business activity. So I think maybe we can get even more emphasis on the latter than we've had before, but it's anyone's guess.
I hope so. Sometimes I'm maybe a little too jaded, but when I hear the words like, Financial Innovation Center, I always think of, have you seen or read Ready Player One? They have the loyalty.
No, I haven't.
Oh, it's really good. But they have this loyalty program in the game that the movie and book is about. But that's like a jail, but they call it the loyalty program. So it's like the opposite, and sometimes when we see these bills like the Freedom Act, and then it ends up being a little different.
Definitely.
But hopefully it's going to encourage innovation.
You have to always be on the lookout for that, for sure.
Mm-hmm. And how can people, well, thank you, first of all. This has been really interesting to me. It was an area, like I mentioned, I just didn't even notice it, and then read your blog on it, and I think it's really important. I'm definitely gonna submit some comments myself, and I really hope everyone listening just takes it. It's one email. It doesn't even need to be. You probably should research it a little bit, but you can just say what you think about it, and you don't need.
Yeah, and everyone should be constructive in their comments.
Absolutely.
Don't just be like, oh, the bit license sucks, repeal it. I mean, that's really not on the table, at least not in this venue, but those who are seriously interested in how to make it a more productive regulation and maybe achieve what I think that the DFS wants to achieve in part, which is to not create a ton more work for it, it'll just slow things down more. So, if we can help them achieve that without defeating the public protection aspects of the bit license, then I think it's going to be a win-win.
Mm-hmm. For sure. And if someone's trying to get a New York bit license, is that something that you handle, Aaron?
Yeah, actually, my firm does handle that, and we have one in process now, in fact. So, yeah, that's definitely in our wheelhouse, as well as similar things like money transfer licenses, FinCEN, MSB licensing. Got good guidance on that for crypto last May, so that's an area more and more having to go ahead and go through with, and then some other connected things like commodities entity registration and compliance, and a little bit. I haven't done much with broker dealer yet, but I have a lot of clients moving towards that. So yeah, that whole space is something I deal with, and including the bit license. So yeah, we're productive about it. I mean, we recognize that a lot of clients are going to have to go through these, and it's more a matter of how to lower the pain factor as much as possible.
Yeah, that's a good way to describe it. And I can attest on one client we worked together on a little bit. I was always really impressed with your work and your speed and your late night responses to things. So,
Thank you.
yeah, if anyone's looking for their bit license, I would highly recommend you to them.
Thank you. Yeah. I hope we continue working together.
Mm-hmm. And how can people get in touch
yeah.
with you?
Yep. Yeah, I was just going to answer that. So, people can find me. It's very easy on my website, krownelaw.com. It's Krowne spelled ROWNE, and then LAW.com. And there's not a heck of a lot to my website, so it should be pretty easy to see what I'm about and get in touch with me through that.
Okay, sounds good. And I'll put the link to your article, the email to make comments, and link to your website all in the the notes of the YouTube and SoundCloud as well. All right. Well,
awesome.
Thank you.
Thanks so much, and I think it's important to get the word out, and always appreciate you organizing these.
Yeah. Well, thank you for coming on. I'm just gonna hit stop here.